Thank you very much, Volker, for the introduction. It is always a pleasure to be here at Plamadiso Talks, and it's a pleasure to be giving this talk about our last paper, which is titled Neutrality and Competitiveness of Data Intermediaries under the DGA, Reality Strikes Back. This was recently published in a Computer Law and Security Review, and this time I had the opportunity to work with a great team. Apart from Tervel, who is today and he is giving the talk together with me, Andrea Palumbo and Alexandra Papageorgiou from KU Leuven, together with Tervel, and George Constantinidis from the University of Southampton, which all of them I met during the Upcast project. So, multidisciplinarity in action, no? At the end, this is what Plamadiso promotes, and this is very important nowadays in these kind of topics. So, the Data Governance Act seeks to increase trust in data sharing, seeks to strengthen mechanisms to increase data availability and overcome technical obstacles to the reuse of data. I'm reading this because it's very, very tough. It's directly from the European Commission. So it entered into force in June 2022, and following, it started in June 22 and had a 15-month period, so applicable since September 2023. We have some time since this was done. So the idea is to check how this has interplayed with the commercial platforms that by that time were already providing data intermediation services, and also how this deals and how this plays and interacts with a thriving research field, which is around data marketplaces and the like in the last years. So let's start. The scope of the presentation, we will start with the law. We will then check what the reality of data markets are, and what the reality of research is. And then we will check, we will identify during this journey several friction points between the law and what is in the market and what is in research. And we will assess those friction points. And finally, we will end the talk by issuing a number of recommendations to improve the law and to make the law fulfill the expectations that it poses in the beginning. No? So first of all, we will address the topics, and we will present the law and the issues. Here I leave the floor to Tervel, who is much more qualified than me to talk about this law. So Tervel, the floor is yours.
Thank you very much, Santi. So first, we'll start with a very brief overview of the DGA itself, since essentially, to put it very simply, our goal here is to understand how well the law can fulfill its objectives given the actual reality of data markets, federated learning, and machine learning markets on the ground, so to say. So first, we can look at the DGA in terms of its ambitions, in terms of the process that led to it, and of course, in terms of what its actual provisions and obligations are. Starting with the need for the DGA, this graphic here is from the European Commission's fact sheet accompanying the Digital Decade Policy Program. It's from 2023, I believe. So right now, these numbers would probably look different in practice. But essentially, it identified some priority areas where the European Commission wanted to increase massively the amount of businesses using big data from 14% to 75%, using artificial intelligence from 8% to 75%, and various other objectives, as you can see there. But what this essentially means is that for these objectives to be reached, the Commission needed to see more data collaborations, more data sharing, and more data pooling between companies, because that's really what AI and big data are predicated upon. Could you switch the slide, Santi?
Yep.
But of course, things get in the way of that ambition. The first one was economic interests. This graphic is from Andrés Azcoitia, investment firm from Silicon Valley, actually, and it really represents the viewpoint of private companies who are afraid that by sharing data and breaking down their walled gardens and data silos, they lose out on the chance to charge more for their products, to capitalize on economic opportunities, and essentially to get more money out of the whole thing. And Santi, if you could also switch a slide. The other concern that companies had with simply sharing more data was that they felt like they couldn't trust what would happen to their data once it was out of their hands and under the control of a third party. And essentially, since data has business secrets within it, this naturally meant that they risked losing their competitive advantages. And essentially, companies observed how previously personal data platforms and the big tech mega platforms very successfully built business models based on monetizing personal data. And they weren't convinced that they had enough incentives to freely enter into data sharing agreements with each other. And this was further worsened by the fact that data sharing was generally done on an ad hoc basis. Contracts and collaborations were set up ad hoc, and this naturally led to high transaction costs each time someone wanted to implement a data sharing arrangement. Santi, can you change? Thanks. And this is why eventually the Commission decided to adopt the DGA. Now, the DGA's objective was to essentially establish alternative services that could facilitate data exchanges, enable data collaborations, and stimulate data pooling, while allowing the data providers to remain in control. It wanted to prioritize ensuring that there would be no other uses of the data beyond what was agreed upon initially, that there were no hidden terms and conditions, no abuses of market power, and furthermore, that individuals were not over-incentivized to share their data to their detriment, the detriment of their privacy, for example. So what we ended up with is a mandatory regime that applies to all entities known as data intermediation service providers. A data intermediation service provider is defined as a provider of a service that aims to establish commercial relationships for the purposes of data sharing between an undetermined number of data subjects and data holders on one hand and data users on the other hand. Now, each of these things has its own legal meaning, and they all have to be true simultaneously for something to be classified as a DIS. But for now, the one thing to keep in mind is that these entities, data intermediation service providers, are distinct from what are colloquially referred to as data intermediaries in the industry. If you go and look at discourse around data spaces and even economics literature, what people call data intermediaries does not always fit under the DISP label of the DGA. Santi, could you switch? Thank you. Now, in practice, the obligations that the DGA imposes on these DISPs are quite far-ranging. They're quite onerous even, and very strict. They include both structural and operational constraints. Structurally, every DISP must be legally separate from any other service provision that may be happening. So only data intermediation services may be offered through the legal entity that is classified as a DISP, nothing else. There can be no bundling of commercial terms with the use of other services. There can be no preferential treatment for access to a DISP's offerings. And the collected data that the DISP may build up on participants, both data providers and data users, during its data intermediation can only be used for the development of the data intermediation service itself, which in practice means, for example, improving the security and fraud prevention capabilities of their offering. But we'll talk more about that in a minute. DISPs can only have very minimal intervention in the data itself, which they intermediate. They can only reformat it for interoperability purposes or specifically at the request of users. They can't offer any additional services besides those that directly technically facilitate the data exchange itself. And that seems to be a very strictly intended obligation. It's supposed to be read and interpreted very strictly. And then they are also forced to offer fair, transparent, and non-discriminatory access to their services. That's reminiscent of a very common concept called fair, reasonable, and non-discriminatory terms. They must implement security, anti-fraud, anti-abuse, and anti-unlawful data transfer safeguards. They must ensure continuity of services, including in the case of insolvency, especially in the case of insolvency, and allow, even when they are insolvent, any actors in their ecosystem to retrieve their data or port it within reason. They must ensure interoperability with each other via, say, adherence to open standards. They must keep detailed records as to their activities. And finally, they even have a fiduciary duty to act in the best interest of individual data subjects whenever data subject rights are involved via, say, the processing of personal data. So it's quite a list. It's not an easy regime to be compliant with. Santi, could you switch? Thanks. So to really understand this regime, we also need to understand how the legislator came to decide on this type of intervention and not on any of the other options that were on the table. So during the proposal stage, during the drafting phase of this law, as part of a study accompanying the initiative to adopt data governance law, several different alternatives were explored by the study authors. There were ones which had lower interventions and lower levels of regulatory interventionism, and ones with higher levels. So you can see them on the graph here. They explored what would happen if the Commission did not intervene at all in the markets for data, what would happen if they tried to stimulate industry-driven self-regulation and self-certification, what would happen if they explored framework for voluntary certification that was governed by the Commission, but still was voluntary to all who wanted to participate in it, or, as the DGA ended up being, a compulsory certification framework for data intermediation service providers. Now, the big question, of course, was which of these would eventually lead to a breakdown in the market, or at least a failure to be as effective and efficient as possible, and which of them would carry the greatest benefits, namely for accelerated company growth, data economy, value rising, data flows, and societal purposes. Now, the study eventually concluded that the greatest magnitude of benefits would be found precisely in a compulsory certification regime, so what the Commission ended up choosing. However, it's very important here to note that this estimate was based on one very explicit assumption that was spelled out in the study. The assumption being that the data intermediation services market was mature enough for such an intervention to be effective. Whether they were actually mature enough or not was not explicitly tested. It was pointed out that this was an uncertain assumption to make. Indeed, the stakeholders, reiterated later by the study authors, expressed that it is doubtful whether the market was mature enough for such an intervention. So, at the end of the day, the Commission went ahead with this higher level of interventionism, but now our task with Santi and my co-authors was to figure out whether perhaps they might have jumped the gun a little in this sort of regulation. And now I will leave it to Santi, I think, to describe the realities of the market.
Yeah. So this DGA pops up in 2022, 2023 enters into force, but at that time, of course, there were many companies already offering data in the market. These are the companies that we made a survey some time ago. We had a look into them, how they trade data, how they set the prices, etc. You have the reference at the bottom of the slide. And what we did is to revisit all of them, or to revisit some of them that were already offering data marketplaces, which is one of the services that are qualified as DISPs according to the to the law. No? Well, we identified that there are three separate business models, different business models they follow. Some of them they are just managing data. They are called data management systems, and they focus on the owners or the people that own and control the data. Some of them focus on the buyers. These are data providers, and they focus on providing data and data-driven services to potential consumers, no, of data. And in the middle, we have these data marketplaces that put in touch data owners and or data controllers with potential consumers of those data. So basically, what we spotted in this survey is that data management systems were building data marketplace platforms to put in the market the data they manage. And even some data providers and data services were putting in the market platforms, data marketplace platforms embedded in their services to benefit from third-party data in the services they provide, which makes perfect sense in terms of business. Well, what we did is that we revisited these 64 entities that all of them providing, out of the 2000, we spotted these 64 entities providing data intermediation services, and we looked for evidence of, first, if they were integrating with other services, these data intermediation services, therefore contravening the provisions of the DGA that these data intermediation services must be separated. And second, whether they were announcing in their websites or in their terms of services that they are doing any kind of processing in the data they intermediate. So first thing that we found is that in the last 3 years, many of these DISPs were shut down. Many of them, especially you see that there are many of them in the data management systems, they were startups or scale-ups that died because they didn't make it to a commercial company, no. But still, it shows that the market is still dynamic and mostly immature in most cases, no. Some of them were acquired or renamed, and many of them switched their business models. Actually, some of them shut down the marketplaces in the last 3 years, which is the case of Salesforce, some Crunchbase here, Dowex, converted from started with the idea to be a marketplace, and then it moved to the idea to enabling third-party data marketplaces as a better business model. Many of them switched their business models and stopped providing data intermediation services to the public, as retail service as such. So it seems the market is dynamic. We had a look also to the active DISPs, and we saw that, we looked for evidences of them, and we saw that many of them were processing data, many of them were integrating with other businesses, and of course, many of them are doing both things. No? Part of the 39 active DISPs, we didn't manage to get evidences by looking into their websites and by looking into the terms of services. We weren't able to find evidences of these two issues, no processing. And for what purpose do they integrate, or for what purpose do they process data? Well, they are integrating data intermediation services with cloud service. An example, Amazon Web Service. Amazon Web Services offers data products within the Amazon Web Service marketplace because it's very interesting for them. Because the moment you use AWS to trade data, you are using their cloud. So it's great. It's great tie. The data management platforms, of course, if they are managing all the data from an enterprise, it's good because at the end they manage this information. They make it available for third parties to share. To be able to access this data. So it's great. Some of them they are integrating AI, machine learning system development. They offer data intermediation services for machine learning plus integration and development of AI-based systems that take advantage of the data they are intermediating. And yeah, they are also offering digital services apart for that. I mean, they provide advisory, they help with pricing, etc., etc. So yeah, I mean, they usually offer other services together with data intermediation. And why do they process data? Of course, I mean, if they are developing systems for AI, they do for that purpose. But apart from that, most of them process data to help consumers select suitable data assets. It's unclear at this point whether this is covered by the DGA. Because on the one hand, this facilitates data transactions, but it supposes that they are accessing the data, and yeah, I mean they can. It's unclear if it is covered by the DGA as of now. And to let consumer test data products they can acquire in the data marketplace, or to expand the functionality of their services. I mean, they can process data for different purpose. By the way, none of them by this time, or at least in December, January is the last time I have looked to this, appear in the EU registry of DISPs, though they are qualified as DISPs, as Tervel was saying before. No? So this is what we found in the market, no? And the conclusion is that to survive in an emerging dynamic market, which we have seen the data marketplace is, real-world DISPs are generally offering the services together with other businesses. This helps bootstrap the platform. Otherwise, you are building a neutral platform. You don't have any users. You don't have any providers. You don't have any consumers. It's much more difficult to bootstrap than if you leverage an already existing business around the data that you are intermediating. No? So that's the issue one that we found. They are arguably using data for purposes that are beyond making it available to data consumers. They are processing the data intermediate. That's an issue with the law, and they are offering pricing and data sourcing advisory, which is second service. They are also interfering with the transactions, the intermediate, etc., etc. So these are the issues that we spotted with the market. What about, I mean, the conclusion is that data markets do not seem to be 100% neutral nowadays. No? What happens with the research? There has been a prolific research field around data marketplaces and around that deal with the peculiar economics of data. It's an elusive asset, freely replicable, non-depletable. I mean, it's quite hard, and there is a huge bunch of economics that it's taking care how to monetize data assets. No? So here we find different data marketplaces. No, that's the first thing. Many research works deal with using data to train machine learning models. Actually, we can find the data marketplaces that sell training data or data as such. You can download it, you can access it through a subscription, and you get updated. You get the access to the most updated data at any time. There are marketplaces that sell pre-trained models of different types, and this we refer to in the paper as model marketplaces. And there are other markets that sells both. And this most of them, they are found nowadays in the research area. I mean, they are trying to build marketplaces that sell training services, where buyers can provide a machine learning task. There are data providers that can provide data that can enhance, that can improve the performance of the model or the AI system that is doing that task. And the marketplace acts as an intermediary. It protects the IP of the consumer, of the application that is this data is going to be used with. And the model, it also protects the data that is used to train this model. And we talk here as machine learning model marketplaces, and there is a part of these marketplaces are betting for a distributed architecture, and they are doing federated learning, where the model is submitted to the peers that have the data, and each peer, each data owner trains the model with the data they have, submits the model back, and it's the marketplace that do all the consolidation of the different models and comes up with a model, machine learning model, AI system that is benefiting from the data from the different companies that are contributing to this federated learning. So there are different types of marketplaces here, and plenty of research works on them. First question that arises is, are machine learning and federated learning marketplaces DISPs? They are intermediating data, but they are not sending data out. They are selling models. So yeah, that's a first issue that comes with this definition. Separate but related research field is that related to data pricing. First thing that is interesting is that the failure to agree on a price seems to be a key reasons why transaction fall apart. And data pricing actually has become a thriving research line in the topic. We were talking about machine learning, and there is, if we talk about machine learning, most people are betting for pricing the data according to the value it brings to the model. For that purpose, if I want to price the data based on the value it brings to the model, I need to process. I need to do some processing. Otherwise, I cannot know which value the data will bring to the model. This is usually done, most papers, there are different ways to doing this. The most popular one is Shapley values. There are some people, incredible though it may seem, that have defined auctions for data, and I'm not referring to the auctions that you do to show an advertisement in a web page. I'm thinking of they create a scarcity by splitting consumers into groups, and by disguising how the auction, they know what are the rules that of the auctions they will face, but they randomly split groups and they assign to a different type of auction, so that at the end they manage to do that. The different consumers have to bid truthfully the value the data has for them, and then they do not allocate, of course, the data to all the consumers, but only to those consumers in certain groups that bid the highest amount. So there are data auctions. Interesting with these two issues is that you can, there are people that are acquiring the same data for different prices because it brought more value to their model, or because they bid higher in the case of the auction. So this raises a couple of questions. First, can machine learning marketplaces process data to calculate the Shapley value, to calculate the value-based price for a machine learning task? That's one issue that we spotted. Second, if we are acquiring data with different prices, different users acquire for different prices, is this discrimination permissible according to the DGA? No, because it promotes transparency, etc. on the topic. Moreover, we have another issue, which is dynamic pricing. Dynamic pricing is widely used in online marketplaces, and they are also planning to use it in of course, data marketplaces themselves. Basically, price will fluctuate based on the demand, based on supply, based on even factors that may even require accessing to personal data of the buyer. Maybe if you are in certain areas, you may price the data higher than you are in different other areas. A first issue with this is whether can machine learning marketplaces process data to calculate a dynamic price for data, or access to personal data to do dynamic pricing. That's one issue that we also spotted. And there is another vast research area which is treating confidential computing. One of the concerns of the DGA is whether these data intermediaries will earn market power due to the fact that they can access many data from different providers, and whether they can acquire significant market power based on this. That is one of the reasons behind being or forcing them to be neutral. But confidential computing, and there are several techniques here, allows to process data without having access actually to the data that you are processing. Of course, I mean, there are different techniques, but the idea is, okay, can data providers send data to a secure enclave where this is encrypted and the data intermediary cannot access the data clean, to say so, and where data consumer can also provide the tasks and data intermediary can do the processing in the middle without having access neither to the code nor to the data, and this would be neutral. Is this neutral according to the DGA? Is this permissible according to the DGA? I mean, with the existing definition, is not clear at all. No? So another point is, can privacy enhancing techniques enable neutral DISPs capable of processing data without contravening the law? That's the last issue that we spot. Okay. So I give the floor back to Tervel. He's assessing these friction points. So, okay, that's your turn, Tervel.
Thank you, Santi. So, as part of our research, we briefly considered how the previous typology that we developed for data marketplaces fits with the DGA and whether the ISP definitions attach the operators of each of those different types of marketplace. Now, to answer this question, one thing we really needed to consider was, is sharing a machine learning model equivalent to sharing data under the DGA's legal definition? And if we remember that the entire definition of a DISP is predicated on them facilitating data sharing arrangements, we can see why this is an important question. So, under the DGA, data sharing is defined as the provision of data for the purpose of joint or individual use of such data. That's not terribly instructive. But then it defines data as any digital representation of acts, facts, or information, and any compilation of such. So this, of course, then leads us to ask, is information also a concept that covers machine learning models? And there was a bit of scholarly discourse on this. Essentially, whether information is a concept that only covers the type of information that is semantic, which contains information about reality, or whether information also encompasses information for reality, as other scholars have called it, which is, say, algorithms and computational instructions. And the consensus seems to be that, indeed, according to the law, algorithms would be covered as information. So sharing a machine learning model back and forth, including for federated learning purposes, is essentially data sharing. So this brings us to our findings that type 3 and 4 marketplaces, so machine learning model marketplaces that offer training services, and federated learning model marketplaces that also offer training services via federated learning, are excluded from the scope of a DISP, mostly because they transform the underlying data in the face of the model by adding substantial value to it and then directly transacting with the buyer of the newly trained model instead of acting as an in-between intermediary. But both typical data marketplaces and model marketplaces, according to type 2, are indeed liable to classify as DISPs. Now, for type 1 marketplaces, that's easy to see why. I would say that they are indeed the primary target of the DGA. But in type 2 marketplaces, where users essentially hire out or purchase a pre-trained model, we need to ask ourselves whether this is something that should fall under the DGA's definitions as a matter of policy. Because remember that part of the DGA's main rationale was that the interests of data holders over the raw data must be protected. And there's a large risk of losing control over this data once it's out into the markets. Now, in type 2 marketplaces, machine learning models are usually hosted and offered as machine learning as a service, and they stay on the operator's own infrastructure. It is theoretically possible via, say, model stealing attacks and various other malicious actions to steal these models, but is this risk real and sufficient enough to warrant imposing DISP obligations on the operator of a this is one thing that warrants consideration. Santi, could you switch to the next slide? Thanks. And then, of course, there's the matter of what Santi already talked about. So to briefly reiterate, if we adopt a strict reading of the DGA's provisions, which seems to be the intention of the legislator when we consider the recitals and various guidelines that have been published, we are left with the fact that data sets cannot be analyzed, their contents cannot be analyzed by the market operator to, say, give recommendations to users searching for data or to offer enhanced searches and enhanced search functionalities in the marketplace. It means that service personalization based on prior user behavior is excluded, as the data that would be gained from observing the users can only be used to improve, say, cybersecurity and fraud detection, very technical aspects. And furthermore, a marketplace operator can't offer any additional tools and services in their market because they can only offer those tools and services that are strictly necessary and directly facilitative of the data exchange itself, not the matchmaking, not anything else. And that includes, for example, no static or dynamic pricing. Santi, can you change the next slide? Thank you. So as a conclusion for this part, I wanted to stress that ultimately the DGA is in a rather unique legal position because it doesn't so much regulate a market as it seeks to create one for DISPs. Now, usually the refrain is that the law always lags behind tech, but the DGA is curious because it's a law that has jogged ahead of technology and markets in many ways. So that's why we're testing it in all these ways. And indeed, the DGA is based on several assumptions. The first of these assumptions are that all of the relevant data intermediaries will be captured by the DISP label, and they will all be competing on a level playing field according to the DISP's regime. Now, there is some uncertainty here, which other legal scholars have already described in more detail, but essentially, the commercial relationship criterion for a DISP needs to be judicially tested, and it is theoretically possible for certain tech giants to try and escape this classification by offering data free of charge. So they aren't classified as DISPs because they perhaps would not be seen as engaging in as facilitating commercial relationships, and instead they would seek to gain benefits via, say, cross-subsidization strategies. Karuvanu and Fink have a lovely discussion of this. The next assumption is that the DGA mandated business model for DISPs is economically viable. Santi already spoke about this at length, but essentially there are currently very few, or should I say, there are currently unproven contemporary examples of viable and sustainable DISPs operating without any other integrated services. Most of them are always embedded with some other services. So this is a risky assumption to make regarding their viability. The next assumption is that total neutrality is a necessary precondition for preventing vertical integration and avoiding monopolies and walled gardens. And here, of course, we need to consider whether this neutrality is an all or nothing proposition, whether it's possible to have some kind of a gradation of neutrality and perhaps relax certain provisions regarding neutrality to allow given personalization activities without completely erasing the neutrality mandate of the ISPs, which is undoubtedly a good mandate to have. And finally, the final consideration here from a legal point of view is how broadly should we interpret terms such as service development and data exchange facilitation, and whether indeed it might be a strategy to allow data markets to develop and observe what users in data markets consider to be must-have services, which marketplace operators also rely on for their commercial viability, and then create carve-outs that allow those services to be offered under the DGA's regime for the ISPs. I think I will leave it off here and allow Santi to conclude.
So here we come to the final section about recommendations and the conclusion of the study. At the end, we managed to build a kind of table with the different issues that we identified, which is the friction point that they make with the DGA. And we started to evaluate what kind of effects we can expect of this. No, Tervel was just starting to say some. Basically, additional costs and economic burden to platforms, reduced competitiveness, particularly of those platforms that are operating in Europe and were born in Europe. It's interesting to see that these other operators didn't even started a registration of the DGA. In general, uncertainty that may deter or hamper innovation, no, in the field. So these are the effects that we saw in the different issues, no, potential effects of the law here. And we started to think about how can we address this in the DGA and given the situation now, no? We identified different potential measures that can be taken, such as clearer guidelines, developing new guidelines for different purposes, to clarify all these aspects that are not clear when you read the law. In the wake or in the trend that Draghi's report proposed, perhaps we can exempt certain stakeholders, especially small enterprises, small mid-caps that are scaling from. We can exempt them from having to fulfill all the requirements of the law, which, as Tervel has said, are quite burdensome in some cases. Perhaps we can use a regulatory instrument. I mean, I know this concern of a data marketplace or a data intermediary becoming an entity with significant market power, but with which we also have regulations such as the DMA for that, no? With that, we probably need to do some amendments to the DGA, and at some point we also spotted this avoidance of mandatory registering and certification of this kind of platforms. No, we identified different types of solution for the different issues that we spotted, and basically we ended up with specific measures that are proposed in the conclusion of the papers. Guidelines should narrow the scope of what the DGA considers as data and specify purposes for which these can process this data to facilitate data sharing and to enhance their services. And also they should tackle the confidential computing. I mean, can confidential data intermediaries process data using confidential computing techniques? This could be interesting also to be a part of these guidelines. Apart from that, we propose to use DMA to address the Digital Markets Act to address the problem of preventing DISPs from gaining market power and incurring in anti-competitive practices and dominate other parts of the value chain. But we think that the DMA already covers this and already covers measures that can be used to prevent this. And there is no need to tackle it in the DEA. And regarding the exemption, these SMEs or SMCs can be exempted from, for instance, separating activities, so that they can bootstrap, they can grow based on these other activities they will leverage on, and when they grow up, to say so, there could be this separation of activities could be contemplated, no, as part of the law. And at some point, this was also part of the digital omnibus proposal, referring the DGA to have a voluntary certification framework, which, by the way, was proposed prior to the impact assessment or as part of the impact assessment. And finally, in the final version of the law, it was moved to a mandatory certification for all the DISPs. And of course, all of this will require specific amendments to the current text of the DGA, which we propose in the conclusions of the paper. And with that, I think we are done. Thank you very much. It's Q&A time and it's discussion time. I hope you found the talk and the paper interesting. And feel free to contact us if you need or you want to make any comment. Thank you very much.